Okay, so let's start the second section, looking at statelessness, treaties and law. Now, we've already covered a bit of the 1954 Convention. We will look at that in more detail. Before we start, I just want to cover a couple of tricky concepts, ones that students are often interested in, and that's good to clear up in terms of how citizenship works. So one of the common questions is around dual nationality and dual citizenship. Because when it's some of the questions in the take-home in the weekly assignments about marriage and divorce and things like that. It means that people can take on second citizenship. So what does that mean? Because people often assume that most countries recognize dual nationality, but it's quite the reverse. Very few countries recognize dual nationality. But that doesn't mean you can't have two nationalities. So probably, someone in this class has dual nationalities, and maybe a Thai and a Canadian citizen. Now, Thailand doesn't recognize dual nationality, but that doesn't mean that it thinks that you're not allowed to have dual nationality. What that means is the state just sees you solely as a Thai citizen. The state doesn't see you as both a Thai and a Canadian citizen. So if it arrests you or makes you go into conscription or whatever, it says it does that, and it just says that you are only a Thai citizen, and that's why they can do it. They don't see you as Thai and Canadian, for example. Okay. Now, there are some countries which don't recognise dual nationality, but they have a way to enforce that, which is involuntary renunciation. We'll come to that next. But just the one about dual nationality, even though countries don't recognise it and may not want you to have a second nationality, there's actually not a lot they can do. Because if you say have Thai Canadian citizenship, the Thai government can't ring up Canada and say, hey, you've got this citizen, we want you to take away their citizenship. Because Canada's not going to take away their citizenship if they awarded it to you. And so to say to Thailand, it's not our problem. That person is our citizen. There's nothing we can do about it. We're not going to take it away. So it means that even though countries may not recognise it or may not like it, there's nothing much they can do about it. But in reality, most countries aren't particularly upset if citizens have more than one nationality. Now, if they are, this is when this idea of renunciation of citizenship comes about. To renunciate means to take away or to say that you're not going to be a citizen of that country anymore. So we have voluntary renunciation, where a person says, I'm not going to be this citizen anymore. It does happen. So, for example, many Americans renunciate their citizenship to avoid taxes. Because in America, you've got to pay taxes no matter where you live. And so if you don't want to pay taxes, you've got to renounce your citizenship. If you want to be a politician in many countries or join an army, you may have to renounce your other citizenships. So, for example, in Australia, there was a big case about 2 years ago where it was found that a number of politicians actually had second citizenship, which is not allowed by the Constitution. So they had to resign from being politicians. They resigned, renounced their citizenship, and then became politicians again. Okay, so it's voluntary renunciation. Now, a much more important form of citizenship, renunciation for human rights, is what's called involuntary renunciation, where states take away that citizenship without that person's approval, without that person liking it. Now, the two kind of famous cases in Asia are Singapore and South Korea. They both have laws where they can involuntarily renounce someone's citizenship. Now, this is, for example, for holding another citizenship. So they don't recognize dual citizenship, and how they punish you for having dual citizenship is they take away your citizenship. So if you're Singaporean and you have a second citizenship, they'll either say, renounce that citizenship, or we'll take away your Singaporean citizenship. Also, it's kind of linked to conscription, I believe. If you refuse to do your conscription, you may have your citizenship taken away. So kind of the reasons why countries have involuntary renunciation is those ones there. Holding other citizenship, if you live outside the country for a certain period of time, Indonesia used to have that rule, live outside of the country for more than 5 years, you lose your citizenship. or if you join a foreign army, or sometimes become a politician in another country, that you may then get your citizenship taken away. Okay, now of course the big one there, which we'll come to soon, is the act of discrimination. We look at the Rohingya, but that's not really involuntary renunciation, that was just changing the laws. Okay, but those are important concepts around citizenship. Let's now look at the two treaties. Oh, sorry, before we get to that, let's look at, in terms of what are the human rights issues for stateless people? Because why is it a human rights issue, and why is it such a concern that we tend to forget that if you don't have citizenship, there's a whole lot of rights, a whole lot of stuff that you miss out on. And it can be a real threat to the personal security of people. So you can have just the simple ones, like, you know, if you're not a citizen, you can't vote. You can't really play in politics. But then more drastic ones is it's very difficult to move. You can't enter and leave countries because you've got no passport. Even moving around within a country, you wouldn't have a driver's license because you can't claim one, so it's going to be difficult. If you're not a citizen, you're going to have much more trouble getting access to education, to health, to opening bank accounts, to a whole range of services, because you don't have a legal identity. You can't get married because you don't have a legal identity. You know, you can't have your marriage legally recognized. Of course, you can have the wedding ceremony and stuff, but it can't be legally recognized because you don't have that legal identity. And probably what's the most disturbing, or the worst violation, is that if you get arrested or if you get caught by the police and you're stateless, many countries, and this includes Thailand, they'll consider you an illegal migrant. So say you're a stateless person in Thailand, you get arrested, you get put into immigration detention, and you can be there forever, because the only reason you can leave immigration detention is when you go back to your country. But if you're stateless and you've got no country, you can be in there forever. And there are some cases of stateless Rohingya refugees in Thailand who have been in immigration detention for, you know, like 10 years or something, because they can't find a resolution to get them out. Okay, so you can see there's lots of problems and lots of threats for stateless people. Now, given that, that's why you have the human rights conventions and the two stateless conventions. Look at the first convention. Now, the first convention, the 1954 one, the main use for that nowadays is that it defines what a stateless person is. We went over the definition in the first slide. What it also does is it kind of recognizes a list of rights as well, but it tends to be that these rights aren't really used that much because they've been superseded. They've been improved by human rights treaties. And stateless people, because they're humans, of course, get human rights treaties. And there are some problems with the rights in the Stateless Convention. They divide it into two types: stateless rights equivalent to other non-citizens or aliens, and that's like owning property, housing, work, and so on. It means that you get treated like any other non-citizen in that country, but then you get treated the same as a national in terms of your freedom, right to religion, freedom of movement, access to education, labour laws, and access to public assistance. So you should be treated the same as everyone else. And it's also meant to kind of give some protection for people, so you're not going to be expelled or punished for being stateless. Okay, so that's the guts of that treaty. Now, if you look at what the problems of that treaty is, as I said before, only half the countries in the world have ratified it, so it's not really that widely seen. As you saw by the definition, it's based on de jure stateless by the law. So all those kind of de facto stateless, or the people who don't have effective citizenship, don't get recognised by it, and so it doesn't cover most stateless people. It's not really a human rights treaty and doesn't respect the rights of stateless people. That's not really a fault of the treaty, because it was written before most human rights came out. It's a 1954 convention, and most treaties, start in 1966. Now, the other problem is it assumes that a state would see stateless people as being legally in the country. But as I mentioned before, for most countries, like including Thailand, if you're in Thailand without a visa, without a passport or proper documentation, you're seen as an illegal migrant and you're put in jail. So even if the Thai government did ratify it, they wouldn't actually kind of recognize stateless people, because they'd say, no, these are not stateless. These are illegal migrants. Okay, and the final problem there is there's no monitoring mechanism for it. It means there's no way to oversee it, nothing to kind of force states to comply with it. Okay, now that was then met with the second treaty, and that's actually wrong. It should be 1961 treaty on the Convention on the Reduction of Statelessness. So that's the second treaty for stateless people, the Convention on the Reduction of Stateless. And what it does is it gives a range of things that states should do to try and reduce the amount of statelessness. So for example, that means that if a child is born into a stateless situation, what's called stateless birth, they should get this citizenship of the country that they were born. That means if you're going back to that earlier slide, if that's a woman who had a Malaysian mother and a Danish father who was born in Thailand, they should get Thai citizenship if the mother or the father can't give them citizenship. It's basically saying no child should be born into statelessness. They just get the citizenship of where they were born. Now, another thing they talk about is this phenomenon, what's called foundlings. Now, a foundling is when a child is abandoned. You know, this happens, I don't know, you know, it would happen, say, in Thailand. So in Thailand, if there's a baby which is born and the police say find it, like it's just a 1-month-old baby, in most cases that baby would assume to be stateless because it doesn't have a birth certificate, you don't know who the parents are, so foundlings get assumed to be stateless. Now this leads towards problems later on of, say, adoption. Like if that foundling is then put in an orphanage, it's difficult to adopt because it's a stateless child that has to eventually get its citizenship. Now what's happened since then is that most countries now just give foundlings the citizenship of the place that they were found. Now another thing it does is that births on boats and aircraft, I mean, it's not a lot of births on aircraft, but it does tend to be births on sea vessels. Previously that child just may be born into a stateless situation. Say if it's a whole lot of refugees escaping the country and that kid is born to refugees, that kid could be assumed to be stateless. But under this convention, it says it should get the flag or the nationality of the vessel itself. Another thing it does is that in many places, and this is like Singapore and South Korea, is that once you turn 18, you've got to decide what your citizenship is. Say you've got a Singapore mother and an American father, you can have both those citizenships. In Singapore, you've either got to renounce your American citizenship and become Singaporean, or take up your American citizenship, or the reverse. You've got to do that at 18. But this one says you can extend it to 21, so you can have 3 years of being an adult before you decide. Now, another thing that it does is it says that involuntary renunciation of nationality can't occur if it makes that person stateless. So if Singapore is going to renounce someone's citizenship for not being conscripted, they can't do that if that person would become stateless under this convention. Now, Singapore hasn't ratified the convention, so that's not going to comply to that, but that's just what the convention says. And then it kind of talks about no nationality should be determined by racial, ethnic, or religious grounds. And that does tend to happen in Thailand and in Myanmar and in a number of countries where, according to your ethnicity, which we'll come back to later, you've got different types and access to citizenship. And of course, the last one is what we call equal descent, that both mothers and fathers should have the same right to give their children citizenship. Now, this convention is not widely ratified, only 75 ratifications around the world, none in South, Southeast, or East Asia, so it's not that widely supported. Okay, let me